Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Viking River Cruises Incorporated v. Moriana. In this case, the court considered this issue: does the Federal Arbitration Act require enforcement of a bilateral arbitration agreement providing that an employee cannot raise representative claims? The case was decided on June 15, 2022. The court held that the FAA preempts the rule of Iskanian insofar as it precludes division of PAGA actions into individual and non-individual claims through an agreement to arbitrate. Justice Alito delivered the opinion of the court, in which Justices Breyer, Sotomayor, Kagan, and Gorsuch joined. Chief Justice Roberts joined as to Parts 1 and 2. Justices Kavanaugh and Barrett joined as to Part 3. Justice Sotomayor filed a concurring opinion. Justice Barrett filed an opinion concurring in part and concurring in the judgment, in which Justice Kavanaugh and in which Chief Justice Roberts joined as to all but the footnote. Justice Thomas filed a dissenting opinion. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Alito delivered the opinion of the court. We granted certiorari in this case to decide whether the Federal Arbitration Act, FAA, preempts a rule of California law that invalidates contractual waivers of the right to assert representative claims under California's Labor Code Private Attorneys General Act of 2004. The California legislature enacted the Labor Code Private Attorneys General Act, PAGA, to address a perceived deficit in the enforcement of the state's labor code. California's Labor and Workforce Development Agency, LWDA, had the authority to bring enforcement actions to impose civil penalties on employers for violations of many of the code's provisions. But the legislature believed the LWDA did not have sufficient resources to reach the appropriate level of compliance, and budgetary constraints made it impossible to achieve an adequate level of financing. The legislature thus decided to enlist employees as private attorneys general to enforce California labor law, with the understanding that labor law enforcement agencies were to retain primacy over private enforcement efforts. By its terms, PAGA authorizes any aggrieved employee to initiate an action against a former employer on behalf of himself or herself and other current or former employees to obtain civil penalties that previously could have been recovered only by the state in an LWDA enforcement action. As the text of the statute indicates, PAGA limits statutory standing to aggrieved employees, a term defined to include any person who was employed by the alleged violator and against whom one or more of the alleged violations was committed. To bring suit, however, an employee must also exhaust administrative remedies. That entails providing notice to the employer and the LWDA of the violations alleged and the supporting facts and theories. If the LWDA fails to respond or initiate an investigation within a specified timeframe, the employee may bring suit. In any successful PAGA action, the LWDA is entitled to 75% of the award. The remaining 25% is distributed among the employees affected by the violations at issue. California law characterizes PAGA as creating a type of qui tam action. Although the statute's language suggests that an aggrieved employee sues on behalf of himself or herself and other current or former employees, California precedent holds that a PAGA suit is a representative action in which the employee plaintiff sues as an agent or proxy of the state. As the California courts conceive of it, the state is always the real party in interest in the suit. The primary function of PAGA is to delegate a power to employees to assert the same legal right and interest as state law enforcement agencies. In other words, the statute gives employees a right to assert the state's claims for civil penalties on a representative basis, but it does not create any private rights or private claims for relief. The code provisions enforced through the statute establish public duties that are owed to the state, not private rights belonging to employees in their individual capacities. Other, distinct provisions of the code create individual rights, and claims arising from violations of those rights are actionable through separate private causes of action for compensatory or statutory damages. And because PAGA actions are understood to involve the assertion of the government's claims on a derivative basis, the judgment issued in a PAGA action is binding on anyone who would be bound by a judgment in an action brought by the government. California precedent also interprets the statute to contain what is effectively a rule of claim joinder. Rules of claim joinder allow a party to unite multiple claims against an opposing party in a single action. PAGA standing has the same function. An employee with statutory standing may seek any civil penalties the state can, including penalties for violations involving employees other than the PAGA litigant herself. An employee who alleges he or she suffered a single violation is entitled to use that violation as a gateway to assert a potentially limitless number of other violations as predicates for liability. This mechanism radically expands the scope of PAGA actions. The default penalties set by PAGA are $100 for each aggrieved employee per pay period for the initial violation and $200 for each aggrieved employee per pay period for each subsequent violation. Individually, these penalties are modest, but given PAGA's additive dimension, low-value claims may easily be welded together into high-value suits. Petitioner Viking River Cruises Incorporated, Viking, is a company that offers ocean and river cruises around the world. When respondent Angie Moriana was hired by Viking as a sales representative, she executed an agreement to arbitrate any dispute arising out of her employment. The agreement contained a class action waiver providing that in any arbitral proceeding, the parties could not bring any dispute as a class, collective, or representative PAGA action. It also contained a severability clause specifying that if the waiver was found invalid, any class, collective, representative, or PAGA action would presumptively be litigated in court. But under that severability clause, if any portion of the waiver remained valid, it would be enforced in arbitration. After leaving her position with Viking, Moriana filed a PAGA action against Viking in California court. Her complaint contained a claim that Viking had failed to provide her with her final wages within 72 hours, as required by sections 101 to 102 of the California Labor Code. But the complaint also asserted a wide array of other code violations allegedly sustained by other Viking employees, including violations of provisions concerning the minimum wage, overtime, meal periods, rest periods, timing of pay, and pay statements. Viking moved to compel arbitration of Moriana's individual PAGA claim, here meaning the claim that arose from the violation she suffered, and to dismiss her other PAGA claims. The trial court denied that motion, and the California Court of Appeal affirmed, holding that categorical waivers of PAGA standing are contrary to state policy and that PAGA claims cannot be split into arbitrable individual claims and non-arbitrable representative claims. This ruling was dictated by the California Supreme Court's decision in Iskanian. In that case, the court held that pre-dispute agreements to waive the right to bring representative PAGA claims are invalid as a matter of public policy. What, precisely, this holding means requires some explanation. PAGA's unique features have prompted the development of an entire vocabulary unique to the statute, but the details, it seems, are still being worked out. An unfortunate feature of this lexicon is that it tends to use the word representative in two distinct ways, and each of those uses of the term representative is connected with one of Iskanian's rules governing contractual waiver of PAGA claims. In the first sense, PAGA actions are representative in that they are brought by employees acting as representatives, that is, as agents or proxies, of the state. But PAGA claims are also called representative when they are predicated on code violations sustained by other employees. In the first sense, every PAGA action is representative and there is no individual component to a PAGA action, because every PAGA claim is asserted in a representative capacity. But when the word representative is used in the second way, it makes sense to distinguish individual PAGA claims, which are premised on labor code violations actually sustained by the plaintiff, from representative, or perhaps quasi-representative, PAGA claims arising out of events involving other employees. For purposes of this opinion, we will use individual PAGA claim to refer to claims based on code violations suffered by the plaintiff. And we will endeavor to be clear about how we are using the term representative. Iskanian's principal rule prohibits waivers of representative PAGA claims in the first sense. That is, it prevents parties from waiving representative standing to bring PAGA claims in a judicial or arbitral forum. But Iskanian also adopted a secondary rule that invalidates agreements to separately arbitrate or litigate individual PAGA claims for labor code violations that an employee suffered, on the theory that resolving victim-specific claims in separate arbitrations does not serve the deterrent purpose of PAGA. In this case, Iskanian's principal prohibition required the lower courts to treat the representative action waiver in the agreement between Moriana and Viking as invalid insofar as it was construed as a wholesale waiver of PAGA standing. The agreement's severability clause, however, allowed enforcement of any portion of the waiver that remained valid, so the agreement still would have permitted arbitration of Moriana's individual PAGA claim even if wholesale enforcement was impossible. But because California law prohibits division of a PAGA action into constituent claims, the state courts refused to compel arbitration of that claim as well. We granted certiorari, and now reverse. The FAA was enacted in response to judicial hostility to arbitration. Section 2 of the statute makes arbitration agreements valid, irrevocable, and enforceable, save upon such grounds as exist at law or in equity for the revocation of any contract. As we have interpreted it, this provision contains two clauses: an enforcement mandate, which renders agreements to arbitrate enforceable as a matter of federal law, and a saving clause, which permits invalidation of arbitration clauses on grounds applicable to any contract. These clauses jointly establish an equal treatment principle. A court may invalidate an arbitration agreement based on generally applicable contract defenses like fraud or unconscionability, but not on legal rules that apply only to arbitration or that derive their meaning from the fact that an agreement to arbitrate is at issue. Under that principle, the FAA preempts any state rule discriminating on its face against arbitration, for example, a law prohibiting outright the arbitration of a particular type of claim. But under our decisions, even rules that are generally applicable as a formal matter are not immune to preemption by the FAA. Section 2's mandate protects a right to enforce arbitration agreements. That right would not be a right to arbitrate in any meaningful sense if generally applicable principles of state law could be used to transform traditional individualized arbitration into the litigation it was meant to displace through the imposition of procedures at odds with arbitration's informal nature. And that right would not be a right to arbitrate based on an agreement if generally applicable law could be used to coercively impose arbitration in contravention of the first principle of our FAA jurisprudence, that arbitration is strictly a matter of consent. Based on these principles, we have held that a party may not be compelled under the FAA to submit to class arbitration unless there is a contractual basis for concluding that the party agreed to do so. The shift from bilateral arbitration to class action arbitration mandates procedural changes that are inconsistent with the individualized and informal mode of arbitration contemplated by the FAA. As a result, class procedures cannot be imposed by state law without presenting unwilling parties with an unacceptable choice between being compelled to arbitrate using procedures at odds with arbitration's traditional form and foregoing arbitration altogether. Putting parties to that choice is inconsistent with the FAA. Viking contends that these decisions require enforcement of contractual provisions waiving the right to bring PAGA actions because PAGA creates a form of class or collective proceeding. If this is correct, Iskanian's prohibition on PAGA waivers presents parties with the same impermissible choice as the rules we have invalidated in our decisions concerning class and collective action waivers: either arbitrate disputes using a form of class procedure, or do not arbitrate at all. Moriana offers a very different characterization of the statute. As she sees it, any conflict between Iskanian and the FAA is illusory because PAGA creates nothing more than a substantive cause of action. The only thing that is distinctive about PAGA, she supposes, is that it allows employee plaintiffs to increase the available penalties that may be awarded in an action by proving additional predicate violations of the Labor Code. But that does not make a PAGA action a class action, because those violations are not distinct claims belonging to distinct individuals. Instead, they are predicates for expanded liability under a single cause of action. In Moriana's view, that means Iskanian invalidates waivers of substantive rights, and does not purport to invalidate anything that can meaningfully be described as an arbitration agreement. We disagree with both characterizations of the statute. Moriana is correct that the FAA does not require courts to enforce contractual waivers of substantive rights and remedies. The FAA's mandate is to enforce arbitration agreements. And as we have described it, an arbitration agreement is a specialized kind of forum selection clause that posits not only the situs of suit but also the procedure to be used in resolving the dispute. An arbitration agreement thus does not alter or abridge substantive rights, it merely changes how those rights will be processed. And so we have said that by agreeing to arbitrate a statutory claim, a party does not forego the substantive rights afforded by the statute, it only submits to their resolution in an arbitral forum. But Moriana's premise that PAGA creates a unitary private cause of action is irreconcilable with the structure of the statute and the ordinary legal meaning of the word claim. California courts interpret PAGA to provide employees with delegated authority to assert the state's claims on a representative basis, not an individual cause of action. And a PAGA action asserting multiple code violations affecting a range of different employees does not constitute a single claim in even the broadest possible sense, because the violations asserted need not even arise from a common transaction or nucleus of operative facts. Viking's position, on the other hand, elides important structural differences between PAGA actions and class actions that preclude any straightforward application of our precedents invalidating prohibitions on class action waivers. Class action procedure allows courts to use a representative plaintiff's individual claims as a basis to adjudicate claims of multiple parties at once, instead of in separate suits. This, of course, requires the certification of a class. And because class judgments bind absentees with respect to their individual claims for relief and are preclusive as to all claims the class could have brought, class representatives must at all times adequately represent absent class members, and absent class members must be afforded notice, an opportunity to be heard, and a right to opt out of the class. and to ensure that the named plaintiffs are appropriate representatives of the class whose claims they wish to litigate, the adjudicator must decide questions of numerosity, commonality, typicality, and adequacy of representation. PAGA actions also permit the adjudication of multiple claims in a single suit, but their structure is entirely different. A class action plaintiff can raise a multitude of claims because he or she represents a multitude of absent individuals. A PAGA plaintiff, by contrast, represents a single principal, the LWDA, that has a multitude of claims. As a result of this structural difference, PAGA suits exhibit virtually none of the procedural characteristics of class actions. The plaintiff does not represent a class of injured individuals, so there is no need for certification. PAGA judgments are binding only with respect to the state's claims, and are not binding on non-party employees as to any individually held claims. This obviates the need to consider adequacy of representation, numerosity, commonality, or typicality. And although the statute gives other affected employees a future interest in the penalties awarded in an action, that interest does not make those employees parties in any of the senses in which absent class members are, or give those employees anything more than an inchoate interest in litigation proceeds. Because PAGA actions do not adjudicate the individual claims of multiple absent third parties, they do not present the problems of notice, due process, and adequacy of representation that render class arbitration inconsistent with arbitration's traditionally individualized form. Of course, as a practical matter, PAGA actions do have something important in common with class actions. Because PAGA plaintiffs represent a principal with a potentially vast number of claims at its disposal, PAGA suits greatly increase risks to defendants. But our precedents do not hold that the FAA allows parties to contract out of anything that might amplify defense risks. Instead, our cases hold that states cannot coerce individuals into foregoing arbitration by taking the individualized and informal procedures characteristic of traditional arbitration off the table. Litigation risks are relevant to that inquiry because one way in which state law may coerce parties into foregoing their right to arbitrate is by conditioning that right on the use of a procedural format that makes arbitration artificially unattractive. The question, then, is whether PAGA contains any procedural mechanism at odds with arbitration's basic form. Viking suggests an answer. Our FAA precedents treat bilateral arbitration as the prototype of the individualized and informal form of arbitration protected from undue state interference by the FAA. Viking posits that a proceeding is bilateral in the relevant sense if, but only if, it involves two and only two parties and the arbitration is conducted by and on behalf of the individual named parties only. PAGA actions necessarily deviate from this ideal because they involve litigation or arbitration on behalf of an absent principal. Viking thus suggests that Iskanian's prohibition on PAGA waivers is inconsistent with the FAA because PAGA creates an intrinsically representational form of action and Iskanian requires parties either to arbitrate in that format or forego arbitration altogether. We disagree. Nothing in the FAA establishes a categorical rule mandating enforcement of waivers of standing to assert claims on behalf of absent principals. Non-class representative actions in which a single agent litigates on behalf of a single principal are part of the basic architecture of much of substantive law. Familiar examples include shareholder derivative suits, wrongful death actions, trustee actions, and suits on behalf of infants or incompetent persons. Single agent, single principal suits of this kind necessarily deviate from the strict ideal of bilateral dispute resolution posited by Viking. But we have never held that the FAA imposes a duty on states to render all forms of representative standing waivable by contract. Nor have we suggested that single agent, single principal representative suits are inconsistent the norm of bilateral arbitration as our precedents conceive of it. Instead, we have held that the changes brought about by the shift from bilateral arbitration to class action arbitration are too fundamental to be imposed on parties without their consent. And we have held that Section 2's saving clause does not preserve defenses that would allow a party to declare that a contract is unenforceable just because it requires bilateral arbitration. These principles do not mandate the enforcement of waivers of representative capacity as a categorical rule. Requiring parties to decide whether to arbitrate or litigate a single agent, single principal action does not produce a shift from a situation in which the arbitrator must resolve a single dispute between the parties to a single agreement to one in which he or she must resolve many disputes between hundreds or perhaps even thousands of parties. And a proceeding in which two and only two parties arbitrate exclusively in their individual capacities is not the only thing one might mean by bilateral arbitration. As we have said, the label party does not indicate an absolute characteristic, but rather a conclusion about the applicability of various procedural rules that may differ based on context. Our precedents use the phrase bilateral arbitration in opposition to class or collective arbitration, and the problems we have identified in mandatory class arbitration arise from procedures characteristic of multi-party representative actions. Unlike these kinds of actions, single principal, single agent representative actions are bilateral in two registers. They involve the rights of only the absent real party in interest and the defendant, and litigation need only be conducted by the agent plaintiff and the defendant. This degree of deviation from bilateral norms is not alien to traditional arbitral practice, and our precedents have never suggested otherwise. Nor does a rule prohibiting waiver of representative standing declare that a contract is unenforceable just because it requires bilateral arbitration. Indeed, if the term bilateral arbitration is used to mean arbitration in an individual capacity between precisely two parties, a rule prohibiting representative capacity waivers cannot invalidate agreements to arbitrate on a bilateral basis. An agreement that explicitly provided for arbitration on a strictly bilateral basis would, under that definition of the term bilateral, categorically exclude representative capacity claims from its coverage. Such claims, after all, necessarily involve the representation of an absent principal, and thus cannot be arbitrated in a strictly bilateral proceeding. A rule prohibiting waivers of representative standing would not invalidate any agreements that contracted for bilateral arbitration in Viking's sense. It would simply require parties to choose whether to litigate those claims or arbitrate them in a proceeding that is not bilateral in every conceivable sense. And while this consequence only follows because it is impossible to decide representative claims in an arbitration that is bilateral in every dimension, nothing in our precedent suggests that in enacting the FAA, Congress intended to require states to reshape their agency law to ensure that parties will never have to arbitrate in a proceeding that deviates from bilateral arbitration in the strictest sense. If there is a conflict between California's prohibition on PAGA waivers and the FAA, it must derive from a different source. We think that such a conflict between PAGA's procedural structure and the FAA does exist, and that it derives from the statute's built-in mechanism of claim joinder. As we noted at the outset, that mechanism permits aggrieved employees to use the labor code violations they personally suffered as a basis to join to the action any claims that could have been raised by the state in an enforcement proceeding. Iskanian's secondary rule prohibits parties from contracting around this joinder device because it invalidates agreements to arbitrate only individual PAGA claims for labor code violations that an employee suffered. This prohibition on contractual division of PAGA actions into constituent claims unduly circumscribes the freedom of parties to determine the issues subject to arbitration and the rules by which they will arbitrate, and does so in a way that violates the fundamental principle that arbitration is a matter of consent. The most basic corollary of the principle that arbitration is a matter of consent is that a party can be forced to arbitrate only those issues it specifically has agreed to submit to arbitration. This means that parties cannot be coerced into arbitrating a claim, issue, or dispute absent an affirmative contractual basis for concluding that the party agreed to do so. For that reason, state law cannot condition the enforceability of an arbitration agreement on the availability of a procedural mechanism that would permit a party to expand the scope of the arbitration by introducing claims that the parties did not jointly agree to arbitrate. Rules of claim joinder can function in precisely that way. Modern civil procedure dispenses with the formalities of the common law approach to claim joinder in favor of almost unqualified joinder. Federal Rule of Civil Procedure 18A, which permits a party to join, as independent or alternative claims, as many claims as it has against an opposing party, is typical of the modern approach. But the FAA licenses contracting parties to depart from standard rules in favor of individualized arbitration procedures of their own design, so parties to an arbitration agreement are not required to follow the same approach. And that is true even if bifurcated proceedings are an inevitable result. A state rule imposing an expansive rule of joinder in the arbitral context would defeat the ability of parties to control which claims are subject to arbitration. Such a rule would permit parties to superadd new claims to the proceeding, regardless of whether the agreement between them committed those claims to arbitration. Requiring arbitration procedures to include a joinder rule of that kind compels parties to either go along with an arbitration in which the range of issues under consideration is determined by coercion rather than consent, or else forego arbitration altogether. Either way, the parties are coerced into giving up a right they enjoy under the FAA. When made compulsory by way of Iskanian, the joinder rule internal to PAGA functions in exactly this way. Under that rule, parties cannot agree to restrict the scope of an arbitration to disputes arising out of a particular transaction or common nucleus of facts. If the parties agree to arbitrate individual PAGA claims based on personally sustained violations, Iskanian allows the aggrieved employee to abrogate that agreement after the fact and demand either judicial proceedings or an arbitral proceeding that exceeds the scope jointly intended by the parties. The only way for parties to agree to arbitrate one of an employee's PAGA claims is to also agree to arbitrate all other PAGA claims in the same arbitral proceeding. The effect of Iskanian's rule mandating this mechanism is to coerce parties into withholding PAGA claims from arbitration. Liberal rules of claim joinder presuppose a backdrop in which litigants assert their own claims and those of a limited class of other parties who are usually connected with the plaintiff by virtue of a distinctive legal relationship, such as that between shareholders and a corporation or between a parent and a minor child. PAGA departs from that norm by granting the power to enforce a subset of California public law to every employee in the state. This combination of standing to act on behalf of a sovereign and mandatory freeform joinder allows plaintiffs to unite a massive number of claims in a single package suit. But as we have said, arbitration is poorly suited to the higher stakes of massive-scale disputes of this kind. The absence of multi-layered review in arbitral proceedings makes it more likely that errors will go uncorrected. And suits featuring a vast number of claims entail the same risk of in terrorem settlements that class actions entail. As a result, Iskanian's indivisibility rule effectively coerces parties to opt for a judicial forum rather than foregoing the procedural rigor and appellate review of the courts in order to realize the benefits of private dispute resolution. This result is incompatible with the FAA. We hold that the FAA preempts the rule of Iskanian insofar as it precludes division of PAGA actions into individual and non-individual claims through an agreement to arbitrate. This holding compels reversal in this case. The agreement between Viking and Moriana purported to waive representative PAGA claims. Under Iskanian, this provision was invalid if construed as a wholesale waiver of PAGA claims. And under our holding, that aspect of Iskanian is not preempted by the FAA, so the agreement remains invalid insofar as it is interpreted in that manner. But the severability clause in the agreement provides that if the waiver provision is invalid in some respect, any portion of the waiver that remains valid must still be enforced in arbitration. Based on this clause, Viking was entitled to enforce the agreement insofar as it mandated arbitration of Moriana's individual PAGA claim. The lower courts refused to do so based on the rule that PAGA actions cannot be divided into individual and non-individual claims. Under our holding, that rule is preempted, so Viking is entitled to compel arbitration of Moriana's individual claim. The remaining question is what the lower court should have done with Moriana's non-individual claims. Under our holding in this case, those claims may not be dismissed simply because they are representative. Iskanian's rule remains valid to that extent. But as we see it, PAGA provides no mechanism to enable a court to adjudicate non-individual PAGA claims once an individual claim has been committed to a separate proceeding. Under PAGA's standing requirement, a plaintiff can maintain non-individual PAGA claims in an action only by virtue of also maintaining an individual claim in that action. When an employee's own dispute is paired away from a PAGA action, the employee is no different from a member of the general public, and PAGA does not allow such persons to maintain suit. As a result, Moriana lacks statutory standing to continue to maintain her non-individual claims in court, and the correct course is to dismiss her remaining claims. For these reasons, the judgment of the California Court of Appeal is reversed, and the case is remanded for further proceedings not inconsistent with this opinion. It is so ordered. Justice Barrett, with whom Justice Kavanaugh joins, and with whom the Chief Justice joins except as to the footnote, concurring in part and concurring in the judgment. I join Part 3 of the Court's opinion. I agree that reversal is required under our precedent because PAGA's procedure is akin to other aggregation devices that cannot be imposed on a party to an arbitration agreement. I would say nothing more than that. The discussion in Parts 2 and 4 of the Court's opinion is unnecessary to the result, and much of it addresses disputed state law questions as well as arguments not pressed or passed upon in this case. Justice Sotomayor, concurring. I join the Court's opinion in full. The Court faithfully applies precedent to hold that California's anti-waiver rule for claims under the state's Labor Code Private Attorneys General Act of 2004, PAGA, is preempted only insofar as it precludes division of PAGA actions into individual and non-individual claims through an agreement to arbitrate. In its analysis of the parties' contentions, the Court also details several important limitations on the preemptive effect of the Federal Arbitration Act, FAA. As a whole, the Court's opinion makes clear that California is not powerless to address its sovereign concern that it cannot adequately enforce its labor code without assistance from private attorneys general. The Court concludes that the FAA poses no bar to the adjudication of Respondent Angie Moriana's non-individual PAGA claims, but that PAGA itself provides no mechanism to enable a court to adjudicate non-individual PAGA claims once an individual claim has been committed to a separate proceeding. Thus, the Court reasons, based on available guidance from California courts, that Moriana lacks statutory standing under PAGA to litigate her non-individual claims separately in state court. Of course, if this court's understanding of state law is wrong, California courts, in an appropriate case, will have the last word. Alternatively, if this court's understanding is right, the California legislature is free to modify the scope of statutory standing under PAGA within state and federal constitutional limits. With this understanding, I join the court's opinion. Justice Thomas, dissenting. I continue to adhere to the view that the Federal Arbitration Act, FAA, does not apply to proceedings in state courts. Accordingly, the FAA does not require California's courts to enforce an arbitration agreement that forbids an employee to invoke the state's Private Attorneys General Act. On that basis, I would affirm the judgment of the California Court of Appeal. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. If you would like to support my efforts to make Supreme Court opinions available to the public, please go to the podcast's website. It's at anchor.fm/SCOTUS-opinions/support. Again, the website address is anchor.fm/SCOTUS-opinions/support. There you can also see other episodes and send a message to me, the podcast's creator. Thank you.